This is lecture number 9, and we've got a lot to go through today, so I'm going to get right at it. Now, when we left lecture number 8, the courts were dealing with the differences of opinion over the power wielded by the national government and the state governments. And from the court's purview, national supremacy won out over state supremacy. Now, the court has continued to rule, especially since the 1960s, on the rights granted us under the Constitution, as well as ruling on that boundary that is established by the 10th Amendment between the national government and the states. So let's look at just what does the federal government have to do when it comes to protecting the states. Well, first and foremost, they have to guarantee territorial integrity. And what that means is no portion of the United States can be given away to another country. At the same time, they have to guarantee a republican form of government, so they make sure that there are no dictators in any of the states. They're also pledged to protect against invasion, as well as domestic violence, which means that the president, in many cases, can send out the National Guard, or even the Army, or anyone else to quell disturbances. There's also, through FEMA and other organizations, assistance with natural disasters, because states may be overwhelmed. Consider Louisiana in 2004. And the federal government is in charge of the admission of new states, which comes through Congress. Now, there are some denial of powers to states that are both in the Constitution and in the constitutional amendments. So what do the states have? Well, nothing specific, let's say. They have no enumerated powers in the Constitution. Their basic reference is the 10th Amendment, which basically says all those powers not given to the national government are reserved for the states. What those are not mentioned. So the states have a degree of responsibility when it comes to education, marriage, voting, because remember, voting is done at the federal, state, and local levels. Marriage is a state issue. Education is done at the national, state, and local levels, but primarily the most affected is at the local level. Public safety, welfare of citizens, regulation on interstate trade, establishment of local units of government, collection of state taxes. Those are the things that are within the powers of the state. And what are the state's obligations to each other? Well, there's what's called full faith and credit. So each state must recognize official documents and judgments rendered by other states. So if you get married, you get, and there's a caveat to that, but if you get divorced, if you go through an adoption, if you are in bankruptcy, and that happens in the state of California, all of those things must be recognized in Nevada, or let's say New Jersey. Marriage right now is the exception. A same-sex marriage that's done in California or New York doesn't necessarily have to be recognized in Florida or Georgia or Texas. They're not going to make you become unmarried, but the privileges that heterosexual married couples enjoy are not extended to same-sex couples. So this comes in Article 4, Section 1 of the Constitution. Section 2, Article 4 of the Constitution is privileges and immunities. And so consequently, with that, the privileges that you enjoy in your state are offered to you when you visit any other state. So if you get in a traffic accident in Texas and you're from California, they're not going to go, oh, got a car license from California. I don't think so. In the simplest terms, the privileges and immunities of any that are enjoyed by any person in that state is also enjoyed by those American citizens who are visiting. Now, interstate compacts are also fairly interesting because interstate compacts have to be looked at by Congress and sometimes certainly by the courts. So when California and Nevada were sparring over what to do with Lake Tahoe, Nevada wanted to continue to develop their side of the lake. California wanted to put a stop on Lake Tahoe development. It went to the Supreme Court, and the Supreme Court sent them both back, mediated it. But interstate compacts are important. The Colorado River is governed by interstate compacts. The states that have the Colorado River run through it subscribe to its water, and they each get a certain percentage of that water. So it's oversubscribed, and so much so that when it reaches Mexico, it's a dribble. No longer the river that you see rushing through the Grand Canyon. Now, as we said the other day, concurrent powers, again, I need you to get these, so we do them sometimes 2, sometimes 3 times, so that you have it hammered into your head. These are powers not denied to the states or given exclusively to the national government. So all states produce different types of taxes, and the state and federal governments have income taxes. The states have property taxes. Local government might have driver's fees, etc., etc. Every level of government produces a budget. Every level of government has different aspects of commerce that they're responsible for. Now, we have to look at 2 of the unique things about our Constitution. One of them is separation of powers, and the other is the checks and balances. Now, the reason that we have checks and balances is it gives an insurance policy that a Republican form of government will not be overwhelmed. And therefore, tyranny is pushed further back when you have separation of powers, because by dividing the power among the legislative, executive, and judicial branches, you make it very, very difficult for tyranny to occur. Now, this has this idea developed and was influenced by Montesquieu, who was one of the thinkers of the Enlightenment. And it was furthered by the experience of the colonials when it came to what had happened in the pre-Revolutionary War period, when a lot of legislatures exercised excessive power. And from the perspective of the founders, that meant that you also had to have, or there could be argued for a need for a strong executive. And the founders were also concerned about one other thing, and that was the danger of one branch combining forces with another branch and going to town on the third. And what has happened is that with the introduction of checks and balances, it's much more difficult to do. So let's look at the background of checks and balances. First and foremost, their background is 18th century. It's an 18th century view of government as something to be restrained, and the modern view of government is something to be used for the common good. That is the battle between the two. The 18th century version of government, one that should be restrained. The new 20th century version is that government should be used to as a positive force for the common good. And again, without checks and balances, the founders had a very big distrust of government, and they wanted to use checks and balances as a means of intentionally building inefficiency in order to prevent government abuse of power, and our system is very inefficient. So the system of restraints in which each branch can check the other two reflects a fear of tyranny. So example, you have the relationship between the veto by the president and the veto override by Congress, both houses. You have the appointment of people and the confirmation by the Senate. Treaty making by the president, ratification by the Senate. Sorry, I got a little interrupted there, but it was for a good reason. I think we were talking about the fear of tyranny that was harbored by the founders, and so what happens with checks and balances is that they put a system of restraints in. And I think the last thing we were talking about was the veto override, appointment, confirmation, treaty, ratification, and the commander-in-chief is restrained by the fact that Congress has to fund any sort of foray that the commander-in-chief wants to engage in. Now, there is political independence within each branch. There's no branch dependent upon the other two for election, with the exception of judges who are appointed by the president and confirmed by the Senate. And the judiciary has one thing that politicians in the legislative branch and the executive branch do not have, and that is a life term. And the founders figured that if you have a life term, you're going to outlive the man or woman who appoints you. And so therefore that would diminish presidential influence over time. Also, the fact that each branch has staggered terms. House has 2 years, Senate has 6 years, presidency has 4 years, would also be a check on each other. And then there's the modifications that have occurred with checks and balances. So we can look at some of these. Now this is the veto. That is, or the executive branch power that is exercised. The president can, and nowadays, propose legislation. Certainly, the budget comes from the executive branch. The president can also veto legislation, which makes it very difficult for Congress to override. But at the same time, by the president, by using the threat of a veto, the president can change the legislation as written to something that is more compatible to what he or she would like to see. The executive branch also has a check on the judiciary through the appointment of federal judges. The enforcement of court decisions was the other thing that we needed to look at. So that means when the courts ordered the desegregation of schools, like in the 1950s, President Eisenhower was confronted with how he was going to enforce those court decisions, and decided, in the Little Rock case anyways, to send the Army in. Congress has a check on the judiciary because they can impeach and remove judges. It doesn't happen very often. I think the last time that occurred was in the early 1990s. But the Senate has the very important power of confirming federal judges that are up for either the district appeals or the Supreme Court. And Congress is used for the amending process of the Constitution, and that is exclusive of the executive branch, which has no role in the amending process at all. Now, the president certainly can argue for or against, but he doesn't have a role in it. Now, Congress has some checks on the executive. They can override the presidential veto, but it takes 2/3 vote of both houses in order to do so. They can ratify presidential appointments. So, for instance, Hillary Clinton as Secretary of State, John Kerry as Secretary of State, had to run those nominations through the Senate. The Senate ratifies treaties. The Senate authorizes and approves funds for legislation. And you'll understand that this is a two-step process when it gets to institutions. And they also, at least until recently, used or practiced the use of the legislative veto, but that has been found to be unconstitutional by the courts. The judiciary has a check or can check the executive because they review actions by the executive branch, especially perhaps actions that refer to either executive orders or executive privilege. And they also have checks on Congress because they review or can review the laws when cases are brought to them that Congress has passed, and litigation is asking the courts to look at checks and balances. Then we look at the modifications. In theory, political parties should weaken checks and balances because political parties theoretically are a way of bringing the branches of government together. Constitution divides government, the political parties bring government together. But in reality, the parties themselves are weak. The Democratic Party and the Republican Party are shadows of what they used to be 100 years ago. And we also have a dominance of only two parties. Each party has a wide range of interests. There's much disagreement within each party itself, so it's difficult to assert such a strong control. Though in the last 10 years, party loyalty, especially at the congressional level, has become a stumbling block because parties are unwilling to compromise. So what we get, and what has been prevalent since the 1970s, has been divided government. The presidency dominated by one party, the Congress dominated by the other party. And that keeps a party in check. They want to go hog wild, like what happened with the Democrats in 2008 to 2010. Sometimes, like them, you pay a penalty. There's also been changes in voting methods. In comparison to how things are written in the original Constitution, senators are now voted on by the people, and that has been true since 1913. But congressmen are also chosen by the people. That has been true since the beginning. But presidents are still chosen by the electors of the Electoral College. Now, theoretically, they are, and they have voted the way the people have voted. But what has weakened checks and balances is that the members of the two branches, the House and the Senate, are essentially chosen by the same electorate. So consequently, there's a weakening of, in theory, checks and balances. However, what has emerged since, again, the 1960s, early 1970s, has been split ticket voting. You vote for the man, not the party. And so most Americans will vote one way or the other based on the person that they see. It doesn't mean that they vote straight Democrat or straight Republican, though that does happen with a large group of people. The third thing is the growth of federal bureaucracy. There is a development, or what has developed over time, and especially since World War II, has been numerous agencies that have legislative, executive, and judicial functions, hint, the IRS. Congress often grants broad authority to agencies and then lets them carry out the general will of Congress, primarily because the bills are so poorly written. So Congress established, for instance, the IRS to collect taxes, and then granted the IRS the authority to help write the tax code, enforce the tax code, and settle disputes over the tax code. So they're judge, jury, and executioner. Thus, the growth of bureaucracy has weakened checks and balances, and there is no way around that. There's also been changes in technology. Nukes, computers, fax machines, satellite communications, smartphones, they've all changed things. So that brings up two opposing viewpoints. The first one is that the President, Congress, interest groups, media have all been able to take advantage of the new technologies, and they have. Certainly President Obama's 2008 presidential campaign, and to some extent his 2012 campaign, will be studied by candidates in the future because it was successful, and because it was successful because of the use of technology. And that, in a sense, strengthens checks and balances. But the president more than anyone else, has been especially able to take advantage of these new technologies. But certainly we give it a name and we call it the electronic throne. The president is able to use television, tweets, YouTube, or whatever to get his or her message out. And that has weakened checks and balances. Finally, the emergence of the US as a world power after World War II means that our areas of national interest have been extended around the world, hence Afghanistan, Iraq, and now Syria. We are the leader of the free world, and we are the only remaining superpower after the Cold War, despite moves by other countries that generally is still true and will remain true for the time being. With such heavy responsibilities, any crisis, like Syria, seems to use or involve the US somehow. And so these responsibilities need to be dealt with in a strong and efficient manner, because power has concentrated itself in the executive branch since World War II. We call it now the imperial presidency. That has also weakened checks and balances. So we're at 21 minutes, and I am going to stop here, and we will upload another one tomorrow. That'll be 10, but this is 9, and this is our look at another aspect of federalism, in particular checks and balances and separation of powers.